Swayam Prabha. Digital India. Educated India.
Welcome students in the class of Transfer of Property Act 1882. Myself, Dr. Amarinder Kumar Ajit, Assistant Professor of Law, Faculty of Law, University of Delhi. Today I am going to deliver lecture number 16, which is on lease. In Transfer of Property Act, the transfer of immovable property has been discussed in very detail. When we used to see day-to-day life, in that the transfer of immovable property used to be happen in many ways, and all are covered under the Transfer of Property Act. In earlier lecture, I have discussed transfer through sale, transfer in case of mortgage. Now I am discussing transfer under lease. According to me, this transfer under lease is one of the second most important kind of transfer under the Transfer of Property Act after sale, because sale is the most common transfer. But if you want to put that who is on second category, okay, so certainly lease is a second category of transfer, which is generally used to be happen in most number after the sale. We have heard lease term since our childhood, okay, but what actually mean? What are the essential criteria? How it is made? Okay, who will be the parties? What will be the conditions within the lease? Which will be the valid one, which will be invalid one? What are the rights of lessor? What are the duties of lessor? Okay, what are the duty of lessee, rights of lessee? All these things we are going to discuss in lease chapter. Okay, so in case of lease, this lecture, which is a introductory, in which I will discuss essential element, duration, and lease how it is made. Mainly, I am going to discuss in detail. Okay, so first of all, keep in mind that whatever kind of transfer we are discussing here in case of Transfer of Property Act, it is mainly, or it is, I will say, only with respect to here immovable property. So lease is also a kind of transfer of immovable property. Okay, and this lease is different from other kinds of transfer. We will see that how lease is different from the other kind of transfer. So under Transfer of Property Act, if we used to go, then section 105 onwards up to 117, this act discusses about lease and related provisions. Okay, so total 14 sections are devoted for lease. Okay, and I will devote 2 lectures within which all these sections provisions will be discussed in detail. So this is the first lecture on lease, and the second lecture will be about rights and liabilities. Okay, so let us start this discussion of lease, its essential element and duration, and its making process, that means how it is executed. Okay. Come to first of all definition of lease. Okay. So definition, what is lease itself? So it is defined under section 105 of Transfer of Property Act 1882. So, according to section 105, lease of immovable property is a transfer of right to enjoy such property. So, first of all, it is transfer of right to enjoy such property. So, which is going to be transferred, the property which is going to be transferred, that is, this property is for the enjoyment purpose. Okay. It is not like in mortgage, it is not for the purpose of security debt, not in case like sale that it is going to be transfer for all things, that means absolute transfer. It is a limited transfer of right, because once we go through the concept of ownership, and I have already discussed in the sale chapter. Okay. So, concept of ownership itself is a bundle of right, which includes so many things, and there are certain characteristics of the ownership also with respect to the property. So, out of those rights which are in that bundle, one right is also related to the lease. Okay. So, only it is a partial transfer of certain kinds of right with respect to immovable property, okay, to the other person for the purpose of enjoyment of that property, made for a certain time, express or implied, or in perpetuity. Okay. Express or implied, that means it may be expressed in a written form, it may be in a oral form, through conduct. Okay. All these things will fall under this, I will explain in detail. Then made this for or in perpetuity also, in consideration of price paid, that is also important part, in consideration of price paid or promised, or of money, a share of crops, service, or any other thing value of. Okay. So, here it is not like only the case in sale, because in sale we have what we have seen, that money is only consideration. In lease, money is not only the consideration. Okay. It talks about consideration of a price paid or promise to be paid in the form of money or a share of crops, even services, or any other things of value. Okay. So, if someone is doing something in lieu of giving that property for enjoyment, that may fall under the category of lease, rendered periodically and a specified occasion to the transferor by the transferee who accept the transfer on such term. Okay. So, it is for periodical time, periodical period, or for a specific occasion, and it is transferor by the transferee who accept the transfer. So, from one party to the other party. Okay. So, this is a definition which has been given under 105, and this definition itself elaborate that what are the essential of a valid lease, and that is very important. So, we are going to take essential from this definition, that what are the main requirement, what are the main characteristic in a proper lease. So, for a proper lease, okay, there is requirement of first of all parties, that is transferor and transferee. Okay. So, any transfer is between two person here. So, there must be two parties in a lease, two parties. One is called lessor. Lessor means who is transferring and who is putting the immovable property on lease, that person is transferor, and the lessee or transferee is the person who is going to take that lease. That means, the person who is going to enjoy the benefit over that property, that person will be treated as lessee. Okay. And lessor is the person whose property belongs to him. So, that means here lessor is the owner of the property, whereas lessee is a beneficial enjoyer of the property. Okay. So, a lease arises in an agreement between owner of the property and a person who proposes to take that property for a term on payment of consideration. Okay. So, it is between two party that the person is proposing that okay, I need your property for this purpose and whatever purpose, because the certain times it may be the property may be already of that character that enjoyment is fixed. Okay. And certain time the property is a multi-use property, certain time the property is completely vacant, that means something is going to be made over that property. So, in that case purpose must be determined for what purpose he is going to be taken. So, here it has been said that the lease arises in an agreement between the owner of the property, and the owner is going to become the lessor because he is going to transfer the partial right of the ownership to the lessee. Okay. And for what purpose it is going to be transferred, certainly it would be mentioned in the lease itself, lease agreement. Okay. So, the person who proposes to take the property for the term of for a term on payment of consideration. The person who transfer the right of enjoyment of property is known as lessor, and the person who takes the property or to whom the right is transferred is known as lessee. Okay. That means, if I am going to see from the perspective of this enjoyment right on the property, then the person who is transferring the enjoyment right, that person is lessor, and the person who is going to enjoy that right on that property, that person is lessee. Because it is always is used to be a confusion in this, that who is lessor and who is lessee. So, lessor, transferor, mortgager, seller, the person who will have ownership. Keep in mind, lessee, transferee, then mortgagee, then this purchaser is a person to whom any right has been transferred. So, in that case the right to enjoy that property is going to be transferred. Okay. So, right of enjoyment is going to be transferred in case of lease. Subject matter of lease is always immovable property. Okay. So, I told you already in the beginning itself, the subject matter of lease is immovable property. And what is immovable property, that has been already discussed in the lecture number 1. I have explained the interpretation clause and section 3, that what amounts as immovable property, because immovable property definition under the Transfer of Property Act, and you will have to take the definition also from the General Clauses Act. Then there is a complete definition of this immovable property you will get. So, whatever kind of immovable property, that may be the subject matter of REIT. And certain times even not only the immovable property in the sense which is tangible in nature, sometime intangible immovable property are also fall under the category of this immovable property, not only tangible. Because I have given the example that if there is a pond, so pond is tangible and pond is this immovable property, but right to catch fish in that pond is, this right is invisible right. Okay. It is a right of the owner, that how he want to use this pond for the purpose of catching fish, for purpose of pisciculture, for purpose of any other purposes of agriculture. Okay. Then there are number of rights are going to be accrue from that pond itself, but which right is going to be transferred, because this is the beneficial right which is accruing from that pond itself, that is also fall under the category of immovable property. So, whoever is going to take 1 year, 2 year, 3 year or 10 years right to catch fish from that particular pond, then this will be also fall under the category of lease. Okay. That the nature of the transaction will determine that whether it is lease or sometimes there may be confusion with license also, but I will discuss in detail. But it never we should confuse with the mortgage, because in mortgage there will be always a kind of debt. In case of this, whether it is license or in case of lease, there is no debt. Okay. So, first of all keep in mind that wherever there will be lease, the lease will be with respect to immovable property. So, the concept of immovable property must be clear for this purpose. Okay. So, here it has been said that therefore, not only land, building, minerals, but also the benefit to arise out of the land, what I have already discussed just now. It says that benefit to arise of land such as fisheries, ferries, okay, etc. are also immovable property. Okay. So, this right is may be given for lease also, because you might have seen in certain places that for the crossing the river there are routes, okay, ferry routes, and these ferry routes is also leased through the auction or through the tender to certain vendor, that for 1 year or 2 year, I just take the for 2 years and for 5 years that will go under the lease. Same is with the parking area. In metros, parking area is also a very crucial point where municipal corporation or any agency put or demarcate certain area for the parking purpose. This parking purpose is related to land. Okay. That parking this parking has been provided on land, and because this is the through land, this right is going to be created that okay, someone can park in this area. So, this parking rights is also transferred to some agency, and they used to collect this parking fees and all, and that area is given on lease. So, that is immovable property, land is immovable property, but creation of parking area and that particular right for parking, that will fall under the category of lease. So, all these things will fall under the lease. Further it says that there may be composite lease, which also lease of a building along with equipment, lease of factory along with machinery. Okay. So, this is also possible, that not only the lease, it is lease of composite lease. There may be clear cut concept on this subject, that when we talk about the immovable property, so within immovable property there are permanent fixtures also, and there are temporary fixtures also. So, when we are talking about the composite lease, that means it is talking about lease of immovable property with movable property. Okay. Just like a well furnished apartment. So, within well furnished apartments there are numbers of things which are movable, just like fridge, sofa, bed and all these are movables. But whenever the owner is going to give on lease, then he will give the whole flat on lease, and that will be also the part of, that means those movable will be also the part of that particular lease agreement itself. But at the same time within the flats also there are number of things which are in a fixed form, just like fan, exhaust, chimney and all, these are the permanent fixture. So, within there are permanent fixtures. So, this will be the part of immovable property. So, if it is merely immovable property, then it is not a composite lease, but if there is a movable plus immovable, it has been said that it will go under the lease. For that purpose there will be no requirement of separate agreement. So, in case of composite lease also, like lease of building along with the equipments and lease of a factory along with machinery, same type of lease may be happen for the gym also. In gym there are the number of equipments, but suppose some person has created a gym and he want to give on the lease for run of that particular gym. So, the whole building plus gym equipments will go on lease itself. So, in the case of composite lease, there will be movable as well as immovable property will both go together, there will be no requirement of separate agreement for it. Then come to the essentials of lease. What will fall under the category of essentials of lease? So, according to this definition, we may see here that there are requirement of two parties, first of all lessor and lessee. Second is subject matter of lease itself, that is immovable property. There must be a transfer of right. Okay. Then transfer of right, that is transfer of this right will be a transfer of limited right, not all right. Okay. Transfer of limited right. Duration of lease, consideration of lease, that is called premium, then acceptance of transfer by the lessee, and a lease must be made in the mode under section 107, which talks about how lease can be made. Okay. So, all these things fulfilled, then there will be a proper lease agreement or there will be a proper lease. So, one by one I am going to discuss this. So, first come to the parties to the lease. So, we have seen that in case of lease there are requirement of two party, that is lessor and lessee. So, lease arises in an agreement between the owner of the property and the person who poses to take that property for a term on payment of consideration. Okay. So, lease will come from owner of property unless and until it is a sublease. Okay. In case of sublease, even the lessee is entitled according to the term and condition, the lessee can do the lease to the subsequent lessee. Okay. So, in that case he will be not the owner, but generally in a proper lease there is a owner of the property is entitled to do this lease. In case of ownership, that means sometime this ownership may be given, this power of ownership may be given through the power of attorney. So, the person who is using that power of attorney, that person is also entitled to do lease for that immovable property. Okay. So, in that person it has been said that the lease arises in agreement between the owners of property, owner of property and the person who possesses to take that property for a term of payment for consideration. The person who transfer the rights of enjoyment of the property, that is lessor, and who is going to take that enjoyment right, that is lessee. Every tenancy is based upon agreement between two persons. Every tenancy here means the lease for certain period, that is tenancy. Okay. So, based upon an agreement between two persons and contains covenant expressed and implied by one person with other. So, that means in between two persons there will be a proper agreement, and within agreement there will be number of certain term and conditions, because we have seen everyone might be knowing that whenever the owner of the flat or owner of the house used to give flat or that house on rent, they used to both party used to sign an agreement, and that is mainly for the 11 month. Okay. So, in that case there are number of term and condition put by the owner in that. That what will be the rights and duties of the lessee and the person who is going to enjoy the benefit of that particular flat or land or house. Okay. So, number of conditions are put on that you will not do these things, and in that way these conditions, when it is agreed by the parties, then they are going to make a proper lease agreement. So, it has been said that an agreement between two persons and contains covenant expressed or implied by one person with other. Next is that every person who is competent to contract, that in these parties, okay, lessor and lessee, question will be who can execute that, who are the parties to this, who may be the parties. So, first of all, any lease agreement is a kind of contract. So, the provision of Contract Act must apply here. Okay. So, any type of lease agreement is in form of contract. So, this contract condition of contract must be fulfilled, and according to contract the person must be competent to contract, okay, and entitled to transferable property or authorized to dispose of the transferable property, not his own, is competent to grant a lease. That means, there we are saying 2-3 things, that it competent to contract, entitled to transferable property, or authorized to dispose of transferable property, not his own. Okay. So, first come to the competency to the contract. The competency to the contract, generally we mean that there is a free consent and party is major. Okay. That means, a person must be above 18 years and person must be of sound mind. Whereas, entitled to transferable property means person must be the owner of that property. Okay. Only an absolute owner of the property can grant lease, okay, for period like any period. Okay. But here it has been also said that the entitled to transferable property, that means he is the owner absolute, or he is the person authorized to dispose of transferable property. That means, the power of attorney has been given, or he is authorized to, suppose not only the power of attorney, suppose take the example of the partnership firm. If the partnership firm is, then every partner will have equal rights and duties. So, in that case any partner can put the property on lease. So, it has been said that the authorized to dispose of person, in the same case it is the principal and agent relationship. Okay. So, whether it is the partner, whether it is the agent, they are the person who are authorized to dispose of the transferable property, not his own. Okay. And then they are competent to grant the property on lease. Okay. But here it has been said that only the absolute owner of the property can grant a lease for any period, that means lease in perpetuity. Only the absolute owner can do, not the other person who is authorized to do that. Okay. The lessee must also be competent to contract. The lessee, that means to whom the property is going to be transferred, that is for under lease, that person must be also competent to contract. A lease may be granted to one or more than one person jointly, that means lessee may be one single or may be the co-lessee also. Okay. So, jointly it can be granted. So, in the case of joint tenancy, in the absence of clear provision to the contrary, the entire body of tenants constitute a single tenant. Okay. So, in case of joint tenancy, where lease has been granted to more than one person. So, in that case what it has been said that in absence of any contract to contrary, the entire body of tenants, that means lessee 1, lessee 2, lessee 3 all joined together will be treated as single tenant. But if within the contract itself it has been written that no, they will be treated differently, okay, then matter will be different. So, so it has been written that case in case of joint tenancy, if there is no such contract to contrary, all the lessee will make a single tenancy under this. Okay. Then the mere fact that lease deed was unregistered, although lessor entrusted the possession of suit property to lessee, will not affect the juror relationship of lessor and lessee. It is very important part that where there is in a mere fact that lease deed was not registered. Okay. It was not registered, but lessor entrusted the possession of the suit property to the lessee. Without registration of lease deed, the property was transferred from the lessor to the lessee for the enjoyment of that property. So, the rule is that this transfer of property without registration of lease deed will not affect the legal relationship between lessor and lessee, meaning thereby that means there is creation of lease agreement between them, even though lease agreement is not registered. So, juror relation is not going to be affected. That means the claim, because what is the purpose of this? The main purpose is that once you are recognizing that something is not registered, even though there is a creation of legal relationship between the party, that means there is a creation of right and obligation between the parties. Okay. So, this agreement where property has been transferred for the enjoyment, but deeds had not been registered, law will presume that legal agreement has been, lease agreement has been created, persons are under the lessor and lessee relationship, and the all the law of lease will apply. That means, rights and liabilities of lessor and lessee will be binding in nature between themselves. Okay. So, that is the main consequence of this. Then come to the subject matter of lease, that is the second essential of lease. Okay. Subject matter of lease is immovable property, I have already discussed. Section 3 and General Clauses Act is very important for this purpose, okay, which defines that what will fall under the this immovable property, but generally we consider that is with the things permanently attached to the earth is treated as immovable property, just like building, fisheries, land, and any benefit arising out of the immovable property is also treated as immovable property. Okay. So, with this basic concept, now we can understand the concept of lease here, that in the lease the subject matter will be always this immovable property or benefit arising out of the immovable property. So, in a case involving contravention of lease term, the lease of the land was granted for a construction of house. Okay. In a case involving contravention of the lease term, a lease of the land was granted for the construction of house, and the only restriction placed on the lessee was not to use the land for purposes other than the construction of house. Okay. That the lease was granted, lease of the land was granted. These days there are the trends that certain cities are granted only on the lease. Okay. That means, whoever is a builder, they will have to take land on the lease only. Okay. So, in that case, and that is for the particular purpose. Just take the example, I will give you example of Noida Development Authority. Okay. So, Noida Development Authority grant lease to the builders, to the property developers, to the owner of the land, that okay, for 99 years this lease term has been given, okay, and within that you can use for this specific purpose, because once they are granting, they are fixing the nature of the use of the land itself. So, it will be commercial place, it will be for educational place, it will be for the residential place and all. They are demarcating, and with that demarcation, that particular lease is going to be granted to the lessee. So, here it has been said that here also in this case a land was given for the construction of house, okay, and was not to use the land for the purpose other than construction of house. Where the tenancy was in respect of building alone and the building was destroyed, the tenancy became terminated. Okay. This is also important case, that is Puthu Kartil, Pran Godan versus Puthu Kartil Parmeswaram. In that case, the Kerala High Court said that where the tenancy was with respect to building alone and building was destroyed, the tenancy became terminated automatically, because we will see the determination of lease also. Okay. So, in that case, when the property is not in existence, then how the lease will remain in existence, okay. And the tenant could not put up any structure upon the land where building stood without the consent of landlord. Okay. However, the landlord could claim recovery of possession of land only through civil court of competent jurisdiction. Okay. That means, there was no creation of further lease after, because it is a completely a termination of lease. But what the tenants did, what the lessee did, that after destruction of that building, he has made a new house. So, for that new house, there was no grant of any lease from the side of the lessor. But court said that there was no creation of new lease in this new house, which has been built by the lessee himself. But if a lessor want to take the land back, because there is a already termination of lease, then he will have to go through the civil court of competent jurisdiction to claim it. Okay. So, in that way it has been said that for what purpose it has been given, purpose has been completely gone away due to the destruction of that building. So, tenancy will not remain alive, that means this lease has been also terminated. Then there are certain cases I have mentioned here. First is T. Lakshmipati versus P. Nityanand Reddy. Okay. In this case, a lease of a house or a shop is a lease not only of the superstructure, but also the site. Okay. In this case, what has been said, the lease of a house or a shop is a lease not only of the superstructure, but also of the site. That means when someone is leasing property, that means it is not merely the building, but the land particular, that is also, and nearby enjoyments right, that is also go through that, okay, lease, for the lease purpose. The site means what? That means what are the right attached to that particular land for the benefit or enjoyment of the land, that will also go with that lease. Next case is Anik Chayamati Devyani versus Prem Mohini Mehra. In this case, Delhi High Court says that in 2003, that the leased premises is not only a building or part of building, but also the land and other thing pertaining to it, and also furniture and other fixture provided by the landlord. Okay. So, that will also simultaneously it will go with the land itself. That land here means that whatever immovable property is going to be transferred, these accessories right attached for the enjoyment of that particular property, that will go through it. But one thing keep in mind, that if something is related to that property, but it is separate one, okay, then that also it must be seen together. That means there is a flat and there is a separate parking area. So, flat has been given on lease, but not on the not the parking area. So, any lessee cannot claim later on, because it must be mentioned in the lease agreement itself that there is no parking available for this. So, later on he cannot claim. Okay. So, that is the possible, but if it is related to flat, and what is the accessories meaning here? That means if something is related to light, air, easementary rights, or certain types of accessibility of market or something. So, all these rights will go with that property. Next important case is Union of India versus Shivdayal, Swan and Sons, 2003 Supreme Court. Okay. This is also very important case. In this case, what the court has said, that the lessee constructed the house and let it for non-residential use. It was held that the act of letting it for non-residential use could not be said to be contravene the restriction in the deed on the ground that the term house implies only residential use. Okay. That means it has been said that lessee constructed the house. Okay. House, it is not about the use of the house, it is about the construction of the house. Okay. So, do not confuse with that the something has been only created for the purpose of residential purpose, then why it has been gone for the non-residential purpose. Here it has been said that the particular lessor has given for the this residential making house to the lessee, and lessee constructed a house and let it for non-residential purpose, okay, rented it for the non-residential purpose. It was held that the act of letting it out for non-residential use could not be said to contravene the restrictions in the deed on the ground that the term house implies only residential use. Okay. Residential use. So, it is the role of or contract term and condition within the deed must be clear. Okay. That means house means not only house for residential. If it would have been written that this house will be used only for the purpose of residential, then the lessee would have been bound by that. But it has been kept that no, on this property lessee will make a house, and what will be the use of house, whether it is residential, non-residential, it was not mentioned. In that case, later on there will be no any condition put on the lessee that you cannot use for the non-residential purpose, it must be within the agreement itself. But in the agreement it was only for the making of house. What will be the use of house, whether it is for the residential and non-residential purpose, it was not declared. So, in that way, so it should not be confused, because if the municipal corporation has given lease and municipal corporation said that this area is residential area and in that area there will be no non-residential activity or commercial activity, then the lessee is bound only to create house for the residential purpose, not for any non-residential purpose. So, this case should not be confused with this kind of example, where the nature of use is already determined at the time of signing the agreement itself. Then third is transfer of right. Third essential is transfer of right. In lease, there is a transfer of right of enjoyment of property, okay, enjoyment of property. So, enjoyment of property is itself for the enjoyment, okay. That means, any immovable property, the value of any immovable property is completely dependent on to what extent it is enjoyable, okay. If the excess, if the enjoyment is very less of that property. Suppose the property is situated very far away from the road and there is no electricity and all, or in a very congested area where for this only person can go on cycle or bicycle or two-wheeler only. So, in that cases, what is the accessibility of the particular land is going to determine the enjoyability of that property or degree of enjoyability of that property. So, in that case, it is right of enjoyment is going to be affected and the price is accordingly it is going to be affected, okay. So, it has been said that any property in case of lease, it is transfer for the purpose of enjoyment, okay. So, enjoyment right is going to be transferred from lessor to lessee and it is only the limited right. Right of enjoyment is transferred only when there is a transfer of possession, that is also important factor. That means, any person can use the property, can enjoy the property only when there will be transfer of enjoyment of the rights, with possession. If there is no possession, then there will be no use of the property. So, possession will be completely transferred, ownership, this rights of enjoyment will be transferred. So, it is the limited right is transferred by the owner with full transfer of the possession, or if there is limited possession, as limited possession means some part has been asked, then only that part will be leased out. So, this leasehold estate is transferred after being separated from the ownership. Leasehold estate is transferred after being separated from ownership. This is a right in rem, okay. Leasehold estate is transferred being separated from ownership and this is right in rem. What is the meaning of this? Meaning is this, that ownership is this one complete bundle of rights. Out of that, suppose these rights are important for enjoyment of leased property. So, this part will be transferred to the lessee, okay, lessee. So, transferred after being separated from the ownership, it is going to be separated from ownership and these rights will go to the lessee. Suppose lessee is Mr. B, but ownership will always remain with the master, that is owner, that is A, okay. And whatever this right has been transferred to Mr. B, who is the lessee, he will have right against the whole world. That means, against the whole world means this is the right in rem that no one can challenge, because this has come from the owner, okay. And owner has also the right of the ownership, and that is right in rem. So, this lease right against immovable property will be also right in rem. So, whenever he will take that possession of immovable property, no one will say that okay, I will be also the part of lease and you will enjoy this right subject to my term and condition. That is not the case. Okay. So, he will enjoy that right against the old world. Okay. So, that is right in rem. So, a lease contemplates a demise or a transfer of a right to enjoy the land for a term or in perpetuity in consideration of a price paid or promise or service or other things of value to be rendered periodically or specified occasions to the transferor. Okay. So, it has been already discussed earlier. So, now I am not discussing at this point. Now, the lease creates a right in rem. It is not merely a contract. The estate transferred to the lessee is called the leasehold, whereas the estate remaining in the lessor is called the reversion. Okay. Reversion. So, whatever I discussed here, that is leasehold, this leasehold with property, this leasehold with property, because lease is a kind of right of enjoyment. Okay. And it is intangible in nature, whereas possession of property is tangible in nature. So, possession will be transferred plus right will be transferred to use it, enjoy it. Okay. And whatever will be left will the, what is the left with the lessor? Lessor is left, that means ownership minus right of enjoyment plus possession. Okay. So, that will be called as a reversion. Okay. So, interest of the lessor and lessee in the leasehold property are heritable and vest in their heirs even after their death. That means, whether it is leasehold or whether it is reversion, both, okay, leasehold and reversion, that means what is left and what is given on lease and what is left with the owner, both can be transferred, because if the lessor died or lessee died, then their legal heir will be entitled to carry those rights and obligation. Okay. So, in that way it is transferable and heritable. Okay. So, these are the two important cases which I have mentioned here, that is Biramji GG Boy Private Limited versus State of Maharashtra and Katli Das Ahiri versus Manomi Das. So, these things has been, that means this case is related to this point, and interest of the lessor and lessee and leasehold are heritable and vest in their heirs after death, that is said in the Kalti Das Ahiri versus Manmohini Dasi. Now, duration of lease. Okay, duration of lease. The essential of a lease is that right to enjoy the property must be transferred. That is true. Certain time, for a certain time, express or implied or in perpetuity, document of list must show the time period of operation of lease and when it is going to commence. Okay, both must be, that means from which date lease is going to commence and up to what time it is, that must be mentioned in the lease agreement. It may commence either in the present or in future or in happening of certain contingency which is bound to happen. Okay. So, lease may start from today itself, from future date, or if something is going to happen. Okay. That means, if it has been said that okay, I will lease out this property to someone when my daughter is going to be married. So, in that means things are this is going to happen then only, or this my property will be leased out on the happening of this death of that particular party. So, or particular heir. So, in that case these kind of the things may be put as a condition. Three types of lease are: lease from a lease for a certain time, periodic lease, lease in perpetuity. Okay. So, a permanent lease providing term can give rise to the tenant landlord relationship. A permanent lease providing term can give rise a tenant and landlord relationship. The only precondition for establishing such relationship is that landlord should have reversed the right to evict the tenant. That right must be there. Okay. If that right will not remain with that, then what is left with the owner? Okay. So, if landlord, tenant and landlord relationship is going to be created, then there must be eviction right must be left with the lessor. Then the lease for life is a lease for a certain time, and for it terminates with the death of the lessee. It is necessary for the lease for a certain time that lease deed should be capable of being made certain or future date, if in the fluxion of time a day will arrive which will make it certain, and this is sufficient for such lease. That means, those kind of incident must be mentioned which is going to be happen, bound to be happen, then it will be called as certain time lease. Periodic lease are tenancies from month to month or year to year. Okay. So, a tenancy from year to year differ from tenancy at will, in that it can only be terminated by notice duly given, and the interest created is not terminated by date of either party. Okay. Whereas, in the case of a lease from year to year is a periodical lease that continue from one period to another period. In periodic lease, the duration of the term is continuous from that period to that period. So, okay. In England, the lease in perpetuity are not recognized. In India, the perpetual lease, agricultural leases are created by an express or presumed grant. Here, a land is held in lease to build residential houses. The lease may be presumed to be permanent lease. That has been discussed in this case. Chapsi Bhai, Danji Bhai Dan versus Purushottam. Then consideration. Consideration is also essential part of the lease. A lease is a transaction that has always been supported by consideration. Without consideration, there will be no lease. Consideration may be either premium or rent. Consideration is paid in lump sum, it is called premium. Consideration which is paid periodically, known as rent. Okay. Rent fixed must be certain, and where it is varying nature, it must be reasonably ascertainable. Then rent need not be necessary in the form of money, because it is in case of lease, I have said that already, that consideration may be in the form of money, may be in the form of services, okay, or it may be in any other form, and that will be a proper consideration under lease. Then agreement to lease. What is agreement to lease? So, the term agreement indicates that there is no transfer of possession or right of enjoyment with immediate effect. Agreement to lease is a contract under which a person promises to grant lease on future date. In an agreement to lease, the parties get bound by agreement for grant of lease to become effective, because it is a mere agreement to create lease in future. Okay, so, it is executory contract, just like a contract to sell. An agreement to let creates only personal obligation which may be enforced by a suit for a specific performance, and that the agreement to lease in writing and accompanied by delivery of possession. So, here this agreement to lease is only a right in personam, okay, where the lease itself is right in rem. Okay, because agreement to lease just you can enforce against the person who has created that, but once the lease has been created, that it can be enforced against other. That means, no one can interfere with the right of enjoyment of that on that particular immovable property. So, question here is, what is the difference between lease and agreement to lease? So, one is right in rem, another is right in personam. Lease operates as a transfer, but the agreement to lease does not operate as a transfer. Lease establishes the relationship of the landlord and tenant, whereas an agreement to lease does not create such kind of landlord and tenant relationship. Distinction between lease and license. Okay. So, license is also a kind of things, right, which is enjoyed on a particular immovable property, whereas that possession is not transfer in case of license. License says that, okay, you will do certain things, you will work certain things, you will enjoy certain things, but possession will remain within the hand of the owner, whereas in case of lease, possession is transfer. So, lease is a transfer of enjoyment of immovable property enjoyment of an immovable property, whereas the license is the right of a person to use the land of another while it remain within the possession of another. Possession is not transferred. In a lease, there is a transfer of interest of immovable property, whereas in license there is no transfer, but the licensee acquire the right to occupy the property. If during the lease period any accretion is made to the property leased, that means something improvement has been made, the accretion is deemed to be comprised in the lease itself, whereas in case of license acquire no right in the property. A lease is transferable and heritable, where the license is neither transferable nor heritable. Okay. Just in a case, a lessee is entitled to maintain a suit in his own name against trespasser or a stranger. A license is not entitled to maintain such suit. Death of either party does not affect the lease, whereas in the case of circumstances, a license is terminated. Okay. Just to give one example, I will give you very common example, that whenever any company or organization used to grant this residential house for their employee, okay, then question here was that whether it was a kind of license or it was a lease for the term of employment. So, court said in that case, because this is a kind of license, it is the property of the particular organization, the person or employee is going to reside in that, okay, and for that period a license has been given to use that property as and enjoy that, but possession is with the employee, possession has not been transferred to the employee in that case. Okay. So, it is a license, whereas if the lease has been given, and in that case any heirs cannot claim that okay, that property will remain with that particular heir after the death of the lessee, licensee. But in case of lease, what will happen? Lessee, after the death of lessee, their legal heir will be entitled to carry forward the lease and they will enjoy the rights of the property. Okay. So, it is all about the creation of lease, definition of lease and how it is made. So, in next class we will see the rights and liabilities of lessor and lessee. Thank you all.